speakers. Our first speaker is Sheena. She's with the law firm of DOL Fact Sheets. And Sheena has been, concentrates on employment and complex commercial litigation and corporate internal investigation. She manages all aspects of litigation proceedings, and she also tries cases in this area of law. She is, for all intents and purposes, an expert on employment law and actually trains and reaches out to corporate HR personnel to teach them about employment law, and that's why we asked her to come join us here. She practices with DOL Fact, but she is a former law clerk to a federal judge, Judge Catherine Perry. What year did you leave Judge Perry?
2011.
So since then, Sheena has been practicing in private law firms, and she does all aspects of cases. So she's going to be talking about overview of employment law with you from the employer standpoint. Then we have Sarah Jane Hunt, and she's with the law offices of Thomas E. Kennedy III. And Sarah has been in civil litigation for the same period of time, since 2011. She went to St. Louis University Law School, and she concentrates her practice on representing employees in the various courts and tribunals around the St. Louis area. And so what we asked her to do is come and give the employee perspective of employee rights as a counterpoint to the obligations owed to the employer and what obligations employers owe to their employees. Now, Sarah Jane also tries cases in all our area courts, and she also does administrative work as well. She has a handout. You will see, did everybody get her handout on wage and hour? That is one of the areas of law that she has tried a number of cases, including and up through appeal. And so Sarah Jane is here to present the employee perspective. I'm thrilled we could give you these young, dynamic women attorneys who are both experts in their field, and I'm going to turn it over to them.
Sarah, I think you're going to be out of the shot over there. Over here. Okay, so welcome everybody. Thanks for coming. We are going to do an employment law alphabet soup. So we're going to be talking about a lot of government agencies, and when we're talking about the government agencies, we'll be throwing out a lot of letters at you. The first thing that we wanted to share was that Missouri is an at-will employment state. And so there are a lot of states like that. Most states are like that. And that means that unless you have a contract with your employer, if you're just hired for a job, then you are serving at will. So you as the employee can terminate the employment relationship at any time, and so can the employer. It's in the language is sort of for any reason or no reason at all at any time, except for all of the times that we're about to tell you about now, right? So when we start talking about the governmental agencies, there are exceptions to that at-will employment doctrine, and that's kind of what we're going to be talking to you about. We're going to start by talking a little bit about federal law and bounce back and forth between federal and state law. So for federal law, we'll talk a little bit about the EEOC, the Equal Employment Opportunity Commission. We'll talk about the Department of Labor and the wage and hour issues, and we'll talk about the National Labor Relations Board. On the state level, we're going to talk about the Missouri Commission on Human Rights and the Missouri Department of Labor and wage and hour issues. So Sarah's going to start us off telling us a little bit about the EEOC, and then I'll tell you a little bit about the state version of the EEOC.
Okay, so what we are talking about are different government agencies who essentially have to, you have to file a charge with them if you believe you have a lawsuit. In certain areas, employment areas, you have to file a charge with them before you can do anything. So if you walk out today, you get hit by a car, you break your back, you want to sue the person who did it, you can walk into a court and file that case the next day. That's how that works. In most employment cases, you cannot do that. And this is what makes employment law even a little bit more complicated, because there are some times you can't, but we'll tell you about the times you can't. So the EEOC is a federal agency. It is the Equal Employment Opportunity Commission. And the EEOC has jurisdiction over certain types of employment suits. So if you believe that you have been terminated from your job because of your sex, because of your race, because of your religion, because of your national origin, I'm missing one, disability, or age, yeah, I just couldn't remember what I said. Then you have to first file a charge with either the federal agency or the state agency that Sheena is going to talk about after me. So the complicated thing is you could, if you believe you have been terminated because of a disability, for instance, you can file with the EEOC, and that charge will then be dual filed with the state if you ask it to, thus preserving your rights in both the federal government and the state government. But the tricky part about all that is that it has to be done in a very short amount of time. You know, most lawsuits, like personal injury, for instance, you have years to file before your what they call a statute of limitations runs out. And that means you have only a certain amount of time before you lose the ability to bring a suit. And in the EEOC, you can't, that deadline is 180 days unless there is a state agency like the Missouri Commission on Human Rights. Then it's you have 300 days, but basically it needs to be from the time that the discrimination occurred. So that's pretty clear, right? No, it's not, because normally discrimination doesn't just happen in a vacuum, this one time thing. So often what ends up happening is there's a long history of discriminatory conduct, and a person doesn't really know what to do about it. And then eventually they might get fired, and for a reason that they believe is protected, maybe a disability, and then they still don't really know what to do about it. And then they sometimes call a lawyer, and then 180 days has passed and there's not really anything I can do. So the thing is, if you believe that you are being discriminated against for any of the reasons that we've discussed, the first thing you should do is call a lawyer. I am a plaintiff's lawyer, so I can tell you from the plaintiff's perspective, we will talk to you. And you will tell us what's going on, and we will tell you if we think, you know, there's something you should do. If you can't get a hold of a lawyer, don't wait to call a lawyer. If you can't get a hold of anyone, if they're all busy, no one's calling you back, you can go to the EEOC and do an intake questionnaire with them. And they have people there who will walk through that with you. And you don't need a lawyer to file a charge. So when you are filing with the EEOC, it is not a lawsuit. You are filing a charge to preserve your potential right to eventually maybe one day file a lawsuit. So it makes it very complicated because there are tons of stages to that. So once you file your charge with the EEOC, I feel like they kind of changed the way they deal with these charges on a fairly regular basis, but at least right now, what I'm experiencing is you file the charge, and then you are assigned an investigator who is an impartial investigator who is going to look into this charge. Then what usually happens is that investigator reaches out to the parties and tries to see if they want to mediate. And what that means is you would use a mediator that is through the EEOC and try to talk about the charge that you made and potentially come to some kind of resolution without anyone needing to go through the expensive, exhausting, time-consuming process of a lawsuit. And there are quite a few cases that are resolved in the EEOC. I used to know the actual number of those that were resolved, but I don't anymore. But if it can't be resolved at mediation, or maybe you guys are just too ticked off at each other that you don't even want to talk about it, you just want to keep moving on, that happens sometimes too, you don't have to mediate, then it is investigated. The investigator calls witnesses, calls parties, which is why the charge that I was talking about is very important. When you believe you've been discriminated against and you are filing a charge with the EEOC to tell them and put them on notice that you believe you're being discriminated against, you need to say what happened. half the time I get people who come in my office who filed it, and it's like 2 lines. I was discriminated against based on my age. Who was there? Who did it? What happened? What did they do? Why do you believe they discriminated against you based on those reasons? Because that information is what the EEOC is going to use to investigate the claim. In very limited circumstances, the EEOC may decide to pursue a case on your behalf. I have only been practicing since 2011. My boss has been practicing for upward of 40 years, and the EEOC has only intervened on 2 of his cases. They don't do it very often because they only have so much, government funding. So what ends up happening if the EEOC does not decide to intervene in your case is you are issued what is called a right to sue letter. This is the magical letter. If you don't have this letter, you don't have a lawsuit. It doesn't happen. There's no way around it. You have to have it. Everybody wants to try to think of all these different ways to do it, but you just got to do it. And there's a positive part of that, and there's a negative part of that. The positive part of it is you have somebody, before you are determining whether you want to go through the emotional, like I was saying before, and time-consuming process of a lawsuit, you have another pair of eyes on it who is investigating, and information is being found out about your claims. And so that's nice, because then you have all that at your disposal when you are making the decision whether you want to sue or not. The other issue is it is time consuming. I mean, sometimes, they have these things for a year. If they have your charge for 180 days and have not issued you a right to sue, you can request your right to sue. And they have to give it to you because it says they shall give it to you. And what that right to sue is a letter that says that you have to bring a lawsuit within 90 days of receipt of that right to sue letter. And 90 days in normal people time, I feel like sounds like a decent amount of time, but in lawyer time is like a blink of the eye. So I have about half of my cases come to me, and I walk my clients through the EEOC process. They found me early, we were in on it, we walked through it every step of the way, and then, when it came time to file the lawsuit, I wasn't surprised. I wasn't having to dig through files trying to figure out what's going on. We file, and it's like that. But there are also times where people just don't know if they really want to do it or not. They just want to preserve their rights and, take it as it comes. And so it'll come, then they might find a lawyer about halfway through or right when they get the right to sue letter. So if this ever happens to you, or if you know someone who is going through this, do not wait until day 89 to call an attorney, because you can't do that, because you have to get all of the information, draft the petition, put everything in it, and get it filed. So these deadlines are crucial, and I have had so many people call me with cases that were viable. They were terrible things had happened, but it would have been a great case, and they just blew all these deadlines. And it's not hard to do. So that is from an employee's perspective, that is what the EEOC, I see of it, because I'm normally in it from a litigation perspective. But it is also often used, like I said, for people to, and their employers to use the mediation process to kind of get to the bottom of what's going on. Maybe someone didn't get terminated. Maybe there's just some racial language being used with coworkers, and they're wanting to kind of work that out. And oftentimes the EEOC mediator will be able to bring the employee and the employer together and get a plan together, and everybody goes back to work and as happy as can be. So it's not always, the EEOC's sole purpose isn't always just to bulldoze through and get your magic letter so you can file a lawsuit. They also have wonderful website material. So if you kind of zone out right now and don't take in anything I'm saying, and a week from now something comes up and you're like, dang, what does she say about that? How many days did I have? The EEOC has a wonderful website that you can go on, and it breaks it down point by point by point by point, because they understand how complicated it is. And I think I guess I could tell you just a little bit more about the types of discrimination that are covered by the EEOC. One of the main acts that the EEOC has jurisdiction over is Title VII. And Title VII prohibits employment decisions that are based on, it protects individuals from discrimination based on race, sex, religion, national origin, and color. And that means it's not just termination. It's in all forms of hiring, of employment decisions, hiring, the decision to promote, your promotions, compensation, how you're trained. Any material major point of your employment, if decisions are being made based on a protected class, it is not okay. It also prohibits creating hostile work environments based on those things. Now, this is very tricky because I always get these calls. My boss is making my life miserable. She has so many favorites. And I say, is she a jerk to everyone? Is she a universal jerk? Because unfortunately, that's not illegal. It's not fair. You might want to look for a new job. I don't know, but I can't, there's no lawsuit there. If there is someone who is making the work environment hostile, which means a reasonable person would think it was abusive, so just like sassy language or sarcasm or things like that isn't going to get you there. It has to be because of a protected class. So if people are using racial slurs on a daily basis, that would be a hostile, depending on the facts, a hostile situation based on race. Or making, sexual harassment comments or touches or things like that. Things that would make your environment at work hostile, but it would have to be based on those protected classes. So unfortunately, your boss who's a jerk to everyone is not covered, no matter how unfair they are. And this might be getting into the weeds a little bit, but I like to tell people this because it really matters in the sense of if a lawyer is going to take your case. It's things that we think about a lot. So if you're filing a case under Title VII, your burden of proof is very, very high as an employee. You have to show that it was the motivating factor. So if your employer has 10 valid reasons to fire you, and then there might be some evidence in there of racial discrimination, it's going to be a very, very hard case to prove. So in federal court in this state, and the way the law is interpreted, you really have to have very strong evidence that the actions are tied to one of these protected classes and in fact are motivated by it. So it's a little bit different than what Sheena's going to now, I'm going to pass the torch to her so she can talk about our lovely state law that has a little bit less of a burden as far as a burden of proof. So that's something to think about if you are filing. Now, like I said, this makes it a little complicated. You can file with the EEOC and have them cross-file with the Missouri Commission on Human Rights to preserve those state claims, which at this moment anyway have a little bit lesser burden. But it might be that when you're deciding where to file, you just go with the Missouri Commission on Human Rights if you have the opportunity to do so, if you get there within the 180 days.
Okay, so I'm going to go over a little bit of what Sarah's already went over, and I think it'll be helpful just in remembering the information. But she's the state and the federal law in this context are enormously different. She said a little bit, and she was being nice. They're miles apart. And so in federal court, you usually are suing under Title VII, and you have 300 days to file your charge of discrimination. In state court, you're usually filing under the Missouri Human Rights Act, which is the parallel to Title VII in federal court. And under the Missouri Human Rights Act, you only have 180 days from the alleged discrimination to file your charge of discrimination. So it's in the federal court, you have a lot more time. to file, almost a year to file the lawsuit, and in state court you have a lot less time. And the burdens that she was just talking about, I'm going to go to that. In federal court, you have to prove that your protected category, your race, your gender, your disability, or whatever it is that you think is prohibiting or making the employment decision unfair to the extent that it's covered by the statute, has to be the motivating factor. So that standard is sort of way up here. It's a motivating factor. So there is an analysis that takes into consideration all of the things. So maybe you got fired because you were late 3 times or something like that. If that is the evidence, but there's also really strong evidence that there was also discrimination based on you being a female, that's what they're looking for, a motivating factor. In state court, the burden is way less. It is contributing factor. So under the Missouri Human Rights Act, the question is whether the protected category contributed to the employment decision. And so that balancing test of, motivating versus contributing is a lot easier to meet. That test is a lot easier to meet. There is some legislation going around now with the new administration to attempt to get rid of that contributing factor language in the Missouri Human Rights Act and raise it up to the federal standard, to the motivating factor standard. So we'll know more about that at the end of the legislative session if that comes to pass. But that is the distinction there. So there's the distinction in the time frame. You have more time under federal law and less time under state law. There's a distinction in the burden of proof, or the amount of evidence that you have to present. In federal court, it's a lot more, and in state court, it's a lot less. And I think one of the other things in the state context that makes these lawsuits very different from each other, from state court to federal court, is individual supervisor liability. So in federal court, you can sue your employer for discrimination. So if the entity is ABC Company, you can sue ABC Company in federal court. But if you sued ABC Company and your manager, Sheena, then Sheena would almost automatically be dismissed from the case because individual supervisors and managers are not liable under federal law for discrimination. Instead, the employer is vicariously liable through any intentional discrimination that's found in the scope of employment. So not if they saw you on the street, sort of at the bowling alley or something like that and pushed you around, but if you have a work environment at work that is discriminatory against you. In state court, though, you can sue a supervisor or a manager. So the supervisor-manager definition is someone who has control over a term or condition of employment. So that's somebody who has the opportunity to hire people, to fire people, to set a schedule, to pass out duties and assignments and things like that. Even someone who is training or has the opportunity to discipline, for example, would be defined as a supervisor under the state law. And so that's the third, I think, really big distinction between state and federal law. And the last, I think, is that there's a little bit of a distinction in the amount of employees. If you're working for a small business, these laws are a little bit different. So under the federal law, you have to have 15 employees, which most employers do, but if you're working for a small business, they may not. But under the state law, you only have to have 6 employees. So it's a little less rigid in that sense. And that's also, if people are out here who are business owners, that's kind of where it falls with the state and federal law.
I just want to talk a little about the things that the EEOC and the Missouri Human Rights Act don't cover that you can still. Okay.
So there are some other types of cases that there are 2 major ones that are often coming up in the employment context that you do not file with the EEOC or the Missouri Human Rights Commission, and those are whistleblower actions and work comp retaliation. So those are more your typical lawsuit path type cases. And when I say whistleblower, I mean if your employer wanted you to do something, or you noticed your employer was doing something that was illegal or against what is called established established policy, which tends to need to be a law, a regulation, an ordinance, something along those lines, and you report that to a higher up, or you report it to an outside agency, and you are then fired because of it, you are you can bring a whistleblower action, and that's a little bit different. So in our other types of cases that we were talking about, in addition to the money damages you also get attorney's fees, which is why attorneys take them, because they know they're going to get paid in the end. These whistleblower actions are a little bit more risky because you are just going to be getting whatever damages you allege. And also, there has to be termination. In a whistleblower context. If you're being jerked around or being yelled at every day because you reported somebody, there's no hostile work environment under whistleblower. You have to be terminated. And then the other type of case that does not fall under the EEOC or the Missouri Commission on Human Rights is work comp retaliation. So if you broke your ankle at work and you file a work comp claim and you were terminated after, and you believe that happened because if you believe that you were terminated because you filed a work comp claim, there's a potential action for you. And work in the state law sense, workers' comp retaliation also has that contributing factor standard, at least for now. This is all subject to change within the next few months, but so again, we're talking about that little bit less burden of proof. And you don't actually have to file a work comp claim to have a workers' comp retaliation case. If you tell your employer, hey, I'm going to go do this, I got to file work comp, like I got to get some, relief for this, my back's killing me, I need to see a doctor, you won't send me to see one, and then they fire you, that's also potentially a workers' comp retaliation case. Is there anything else?
We could just talk about retaliation generally, and I'll say with the whistleblower claims being terminated, we as employment lawyers use that to mean a lot of different things, right? So it could mean that you're actually fired, or you're what is considered constructively discharged. So constructive discharge is important because that is what an employer will say is a voluntary termination. So you decided, because my work environment is not conducive to, the terms and conditions of my work environment are oppressive, I'm forced to quit. And that's still considered termination under the law, a constructive discharge. But about retaliation, this is a good point for us to bring. This is something that you can bring under Title VII or under the Missouri Human Rights Act. So we're going back to that filing of the charge sense of things, where you file with the EEOC or the Missouri Commission on Human Rights. And retaliation is an often sort of misunderstood, even by lawyers, concept as a legal principle. What retaliation is that you're coming to the EEOC or the Missouri Commission on Human Rights, and what you're saying is, I was then retaliated against because I made a complaint. And so often, it's what came first, the chicken or the egg, right? Because you can't just complain about anything. You have to actually be complaining about discrimination or harassment or something like that based on a protected category. So there still needs to be the allegation of discrimination. Whether or not the allegation is merited that's a different claim. That's what we were talking about first, right? The discrimination, the hostile work environment, so on and so forth. If you complain about that, and then let's say you make a complaint and then you get terminated, then you would have a retaliation claim. A lot of times people will want to say, I complained that we didn't have a soda machine or something like that, and then I just got nailed. I kept getting disciplined after that. Well, that's not really what it's designed to do, right? Your complaint has to be about unfair treatment under the law, not just about any complaint, right? Or we'll have a situation where, for example, someone says, I disagreed on a management level. This was the policy that they wanted to be set. I voted against it or something like that. And then after that, I was taken out of leadership or something like that. That's not actually a retaliation claim. You first have to have a discrimination or a harassment claim and a complaint as well. And then you have a retaliation claim. And so after you make a complaint, you have engaged in what we call protected activity under the law. And so you can't be then retaliated against for engaging in that protected activity because it's your right to complain if these laws are being violated. Does that make sense?
It is also true that if you see that your coworker is being sexually harassed on a daily basis and you complain about their being sexually harassed on a daily basis and they retaliate against you, that is also a retaliation claim. But that happens not as much. It actually generally happens more under the context of like the Americans with Disabilities Act, like a teacher's advocating for a kid or something along those lines and gets retaliated against. But you can also be advocating for someone else. Or if somebody, asks or subpoenas you to testify in their discrimination case and you do so truthfully and you are retaliated against, that can also be a retaliation claim.
Do we have any questions about what we talked about so far?
The protected class, you said age, sex, religion, disability, national origin, color, gender. Is the gender inclusive of the LGBT community?
It depends.
Right.
Yeah.
That is a very
astute question.
Could you restate the question?
Okay, great. So she wants to know if the protected categories, when you say gender, does that mean the LGBTQ community? And there is some debate about that, right? So under Title VII, there's a split amongst the circuit courts about whether or not Title VII covers sexual orientation and sexual preference. The EEOC, though, has taken the position in its strategic enforcement plan, which it came out with in like 2006, that this is protected, right? So the EEOC is often what I call an agency with a theory in search of a law to support it. And they do develop the law in that way because they're litigating the cases. So that is part of the EEOC strategic enforcement plan. It's one of 6 points, so it's one of the things that they focus on more than anything else. And they have taken the position and issued guidance saying that it is protected under Title VII. There are a number of federal courts who disagree with the EEOC, and there are some who don't. In Missouri, the Missouri Human Rights Act has not been extended to protect in that way, but there are local ordinances that do.
And there are also legal theories that can work depending on your facts in Missouri. So what we have sometimes is we had an individual who was gay and he worked in a typically male-dominated field, and he was constantly told that because he was gay, he needed to act more manly, he needed to act in a certain way that men are supposed to act, and that passed muster in my case as sex discrimination. Stereotyping someone because of their sex is not okay under the Missouri Human Rights Act. So because my facts fit, that particular instance worked. But the law has not been very well developed on that. I don't even know that there are any high courts decisions that explicitly talk about it. But it was one that we thought fit squarely within the language that had been used in other sex stereotyping types cases, so it ended up going forward and we didn't have any problem. But I think just without those facts, I don't think I would have filed it in Missouri.
And a good thing that you can look at if you want to read more about this is there was a PricewaterhouseCoopers case. PricewaterhouseCoopers is like one of the very top firms, and they had a woman who people were saying was being too manly in her presentation style. She was being too aggressive and she needed to be more polite or ladylike and things of that nature. That was the kind of language she was being given in management meetings and things like that. And she brought a lawsuit under Title VII on that basis. And that is the lawsuit that sort of started the whole analysis. And so anytime you look at that PricewaterhouseCoopers and sexual orientation or gender identity, you will find, you Google that, you'll find 100,000 things you can read if you want to become more proficient in that. Any more questions about what we got one over here.
Am I correct to assume that the EEOC is independent, not independent, of the federal commission, not under cabinet level? it operates independently from cabinet positions?
Well,
Part of the Department of Labor, Commerce?
yeah.
It is not part of the Department of Labor, but it is similar to the Department of Labor. It is a commission. It's not a department. It's a commission. So, but it's not
How well funded it is depends on
the administration.
the administration, and how well funded it is how much they can do, basically.
Because while you were talking, I was reading how Trump's possibly going to appoint people that are basically going to blow this thing up. Is it possible? I mean, is it not to predict politically what would happen, but is it possible you could be out of a job because the EEOC has no money to do anything or no staff?
No, because what the EEOC does with the cases when they don't have the resources to litigate them is they issue right to sues, and I sue them. I sue the defendant. So I don't need the EEOC to litigate for me to bring a case. It's helpful. I also do fair housing cases, and every once in a while the Department of Justice wants to intervene, and when that happens, you have the might of the federal government behind you, and you have all their cool toys and stuff, so it's really nice when they do that, but I don't need to do it. What that right to sue letter gives you is a private right of action. That means you don't need the EEOC anymore. It's nice if they want to, play ball with you, but it doesn't happen that often because they have, and often, like Sheena was saying, they have their list of things that they do very targeted because they do make an impact when they do it like that. So if you don't have a case that's kind of fitting into what they're focusing on at the time, I don't want to speak to them. I mean, they do what they do, but typically, their cases are going to be the ones that they're focusing on that type of law at the moment.
So if their budget was cut by 50%, it wouldn't really, you're...
Right. I mean, it would impact things because, I need the EEOC staff to issue the right to sue. Someone has to do that. You have a right. So you also have a right to your file, both at the EEOC and the Missouri Commission on Human Rights. You don't get the file. I mean, there are portions of the file you can get as you go along, but you don't get it until you get your right to sue. So oftentimes, I might not know if this is something that the client might be on the fence as to whether they really want to litigate, and they want to see the file just to see what the other side says. So in that EEOC process, we write our charge, and then the other side has a chance to do their position statement. So if there was no one to give me the right to sue, to actually issue it to me, or the file, that could be problematic. Because the other thing to remember in Missouri is that another deadline is you still have to file your lawsuit within 2 years from the time the discrimination happened. So if they're taking forever with your lawsuit or to investigate, or you don't know what's going on, or you're not sure, and 2 years have passed before you get your right to sue, you can't file a lawsuit even if you get a right to sue. I know that's kind of a curveball. So to answer your question, if I couldn't get my right to sue letter in time because there's not enough staff to issue it to me, that could definitely be an issue. But I don't know that that's been a problem.
No.
You said under Title VII you need to show why it was done. Do you recommend people take very detailed notes of conversations? Do they try to get emails that are evidence? What do you do before you even come to the lawyer?
Well, people do. Now, typically, everything that you have and you've written down, ends up in discovery when we file and we start exchanging evidence, goes to the other side. So, it's not a bad thing to do. And
it could make your case, or it could totally bust it up.
It could totally bust it up, because that means that those are the facts that you will be married to. Even if you didn't accurately write it down, it doesn't really matter because it's on paper forever. So I do recommend that employees engage with their employers before they run off and file a lawsuit. And what I mean by that is, sometimes people will tell me that they've been discriminated against for 4 years, and, all of these different things have happened, and I say, did you ever tell anybody? Is there a witness? Is there anybody besides you who can sit on the stand and tell me this? And it's like, no, I didn't think it'd do any good. And that might be right. That could totally be true, where you just feel so beaten down that you didn't think that it would even matter. Well, I think it does matter in the sense of if this employer is actually wanting to do the right thing, it might be an opportunity for people to come together and get this figured out. If they really are a jerk who's a racist, then you have all these times where you've complained about it and it's great evidence. So, I think it could work. Those are the types of things I think you should do if you're really feeling like this is happening to you. Because on one hand, it's a time, it might be the first time that the employer has ever heard this before. And, they should have a chance to respond to that. Also, it just for the sake of your case, if, you are saying this has been happening but no one but you knows about it, that's just not a lot to go on for a jury. I don't think we'd even get to a jury, frankly.
And just from the employer's perspective, to the extent we have people who are managers here or who are small business owners, it is important that you write down what happens when somebody comes to you and complains. Documenting your investigation is very, very important for an employer, and the reason is there's a defense, obviously, in most employment cases, that you had a policy that prohibited discrimination and that you took prompt remedial action to correct any discriminatory or harassing behavior. So the first question that I'm going to ask, if there is a person who has said, I've been discriminated against for 2 years and I'm representing the employer and they never complained, the first question I'm going to ask you when you get on the witness stand is, did you ever complain? And you're going to say no. And then I'm going to say, so-and-so, Sally, didn't have the opportunity to address your concerns, correct? And it's just not good evidence. Also, with the documents, there's times, there are going to be times where you write things down and it'll be good to have a document that says what happened to you, give the chronology of events, because you won't be able to remember every single detail. The times where it's bad is that, like we've already said, when you say, not only did that happen to me, it happened to Sarah and Jane and everyone else, right? So, because then it's not a discrimination case make, right? Because it's like this person has done this on this day and that day and that day to every single other person who works here, right? So it's because part of what the employment laws are, and this is really important because there are a lot of cases that say it, is that the employment laws are not a civility code. They're not meant to make people be nice to each other. What they say is that you cannot discriminate against someone based on a protected category. So it's about being singled out on an improper basis. So that's when the notes, if I get a pile of notes that have been for 2 years and there is a note about a white person and a black person and a man and a woman and then I'm like, okay, this is not good evidence for you, but thank you.
Right. And so we basically, like lawyers often do, didn't actually really answer your question all that well. But I think that,
I thought
you have to, but I mean, as far as like, should you do it, should you not do it? Yeah. It's basically like, trust your instincts, and if you think you need to write down notes and you think you can do it accurately in a way that portrays what's happening, then, then do that.
What about in Missouri? Isn't it true that as long as one party agrees to it or is conscious of it, they can record the conversation?
Yes.
Record the conversation. You're not forgetting things as you write them down.
Right. As long as both of you are in Missouri, that is true, or both of you are in a one consent state. And the recording things are again, it's just another thing. Sometimes good, sometimes bad. Sometimes it is evidence and it shows and it makes your case. Sometimes it just makes you kind of look like you've been looking for a lawsuit for 2 years and you've been just piling up all this stuff and hoping something would stick. So, which is why it's just kind of hard to tell you on a test basis. Yeah, like yes, do it, don't do it. It's kind of a use your judgment kind of thing. Yes, sir.
Of all the various categories under which you can sue, race, gender, which are the harder ones to prove and which are the easier ones to prove?
I think in my practice, the race cases are typically harder to prove. People generally know these days that you shouldn't say racial slurs or do overt things, which typically I think, even though that's not what you have to have race discrimination, that's typically what I think jurors are looking for. I think often I don't want to say, they're not easy by any means, but the disability cases tend to have a lot more of a paper trail because people are often asking for time off work, or there is usually some kind of document somewhere that's discussing what's going on with the disability. And then, in my better cases, it's like, there's been all this conversation, no accommodations have been made, and then when they go outside and get a doctor's note, then they're fired the next day. They typically just have a little bit more evidence. And I also think that people who, your jury pool is made up of everyday people. Not everybody on your jury pool is going to be able to identify with being racially discriminated with, but almost everybody knows someone with a disability or someone who's been sick for a long time. So you get a little bit more of an understanding in those cases versus the other cases.
And I would agree with that 100%. I think that's dead on, is that race cases are the most difficult to prove, and disability discrimination cases are. I think we might be at time for a break.
Okay, do we want to do one more question?
I'll be back.
Okay, sorry.
I noticed that you did the Looney Tunes thing and that you're supposed to be sensitive to people with disabilities. I would just watch, how that affects people who are cognitive others and mentally ill.
Yeah, I don't think I did that. Oh. Okay, do we have one more question?
Yes.
Oh,
I have been paying.
sorry. We'll get you two, sorry.
No, that's okay. It's, if a person just, because now I've learned.
Oh, hold on. Now we have two warring questions. So we're going to do you, ma'am, and then we'll do you afterwards. I'm sorry, I'm having a hard time seeing past the middle because the lights are reflecting off my glasses. So,
But anyway, now I know the days involved, okay, between federal and state. I know that, and I want to save a little bit of time, okay? How does a person know, other than the number of employees, how does a person know whether I should go and get in some line in a federal building or go and get in a line in the state?
you should just call a lawyer because, the facts of your case are going to be very dependent on that. I mean, typically, the way the law stands now, it's easier to win a case in state court. So I would, at this moment, tell you to stand in the state court line if you can, no matter what. But that is probably going to change somewhat soon. Sorry. Yes, ma'am, the one I cut off before.
The question is about the legislation that may change somewhat soon. The standard of contributing evidence is being shifted. Do you know anything more about that bill? I'd like more information about that. You keep saying it's going to be changing, which means everything you're saying is changing.
Right. Well, I want to be very sensitive because I have very strong views about what should be done with this, and I don't want to be off-putting. But so what they want to do is they don't want the contributing factor to exist anymore. They've been doing this every year for like the past, 10 years? And it never got through Nixon. So this is the same bill that's been going every single year, but it's a number. But what we can do is we can make sure that...
What's the number?
Right. I don't have it on the top of my head because it's also...
Your website to be listing of all bills that impact the administration of justice and law, and there are more than one bill that...
Right. So they're trying to change the standard for work comp retaliation. In one bill, they are trying to change the whistleblower ability to sue under the whistleblower protection in a completely different bill. And then the Missouri Human Rights Act, as it stands, is also they are looking to change that. And there's 5 different bills. So, and I don't mean to be wishy-washy. It's just because they're constantly changing and different things are.
And they've been. We haven't taken the pains to remember the HB whatever because this is like year number. I don't even know what. That there's been many times that the contributing factor standard has been changed or the legislation has been proposed to change it, and a number of times even when it's passed, the governor has vetoed it like 3 times in a row.
Right.
And now we're under a new administration. administration, right? So those same sorts of bills and even more aggressive ones are taking place, and you can find all of those, I believe, on the Missouri Bar's website.
And there's been some news on the different types of hearings and the arguments and the hearings on that as well. So I think do we need to do a bathroom break? And then we're going to talk about the very exciting topic of wage and hour when you all get back. It's going to be great. It's my favorite thing. Okay, I think we're going to get going again because we did start a little late. So we are going to be taking... We're going to take questions at the end of this section, at the end of each section, and then we're going to try to reserve enough time to have general questions at the end. So if you had questions about the first section, feel free to ask us at the end. I also have business cards if anyone wants to email me. I love talking about employment law. It's what I do every day. I have no problem telling you. So what we're going to talk about now is wage and hour law. And so this has to do with how much you're paid, how you're paid, and the types of deductions that an employer can make from your paycheck. Or alternatively, if you are in management or you have your own business and you are trying to figure out how to wrap your head around how to pay people and whether they're entitled to overtime, that's the type of stuff that I'm going to be talking about. So this is, I'm going to talk about the Fair Labor Standards Act, which is the federal act. All of those cases need to be filed in federal court. However, there is a Missouri state equivalent of the Fair Labor Standards Act that's pretty much exactly the same as the Fair Labor Standards Act. Is anybody from Illinois or live in Illinois or have business in Illinois? Okay, so just to let you know that the state Illinois Wage and Hour Act is much different than the Fair Labor Act, and it's much more protective. So I will stick to talking about mainly the Fair Labor Standards Act because it's basically the same as the state act. There are virtually very few differences. So the Fair Labor Standards Act is governed by the Department of Labor. You have the option of filing a wage complaint with the Department of Labor, the federal Department of Labor. The state also has a Department of Labor. What that would do is you would fill out, I think they have it online. You access a complaint form. You say things like, they're taking, random deductions out of my paycheck, or I think I'm entitled to overtime and I'm not getting it, or I'm not being paid in accordance with the minimum wage, and it's possible that they will investigate and pursue your employer on your behalf. The Department of Labor, like the EEOC, is a government agency, and it doesn't have the ability to, get involved in every single case. So usually what I tell people is to contact a lawyer, because it might be that you have an amount of wages that is not enough really to make it worth your going through the process of a lawsuit. And I keep saying this because I don't know that everybody realizes that lawsuits take years, in the best of circumstances, from start to finish. So when thinking about whether you want to file a lawsuit, that's something to take in mind. And, usually it's how, if it's an amount of money that you're talking about that is, significant to you, but maybe not worth it to you to go through a very rigorous legal process, then it might be that you make the complaint through the government and see what they can do on your behalf. You don't have to do that, though. It is not like the EEOC or discrimination cases where you have to file this complaint with the federal government or the government to say, hey, I'm not being paid correctly. You can file a private right of action. And as I was saying about the EEOC, I don't know who's in charge of government websites lately, but they're doing a fabulous job, because the Department of Labor has fabulous resources on these. They are called fact sheets. And and they talk about the different the different things that are improper under. We can specifically go into them as we go on, but improper deductions, whether someone is exempt and entitled to overtime or not, all the different factors. They have these wonderful fact sheets that are written not in legalese. Like, anybody can read them and pretty much get a good grip on what's happening, and they are there all the time. So if you wake up in the middle of the night and you just start thinking about this and obsessing about it, go to the Department of Labor, check out their fact sheets, educate yourself. It's a great resource. So the Fair Labor Standards Act is a kind of trendy type of litigation lately. Like, people are starting to do it more and more, which is kind of weird because it's like been around since the New Deal. Like, it's not a new thing. It's not new, but like, it's just, I think it's very dense, and there are a lot of regulations that accompany it. So I just think that lawyers maybe have just taken this long to figure out what the thing says. I'm not sure, but it basically says that everyone needs to be paid a minimum wage. They're entitled to overtime if they work over 40 hours in a work week. It also establishes record-keeping burdens on employers that are kind of rigorous, and if you are an employer, you really want to look at those because it's a big problem for you if you have a wage case and you don't have those records, and we'll go through that too. So it is this very employee protective statute, and currently the minimum wage in the federal minimum wage is $7.25, and if you look in your little handout that I gave you, it has all the Missouri one just changed, so Missouri's changes every year, so Missouri's a touch higher. So that says that everybody, basically the baseline is everybody needs to get paid this an hour, right? And then, like all legal things, it says unless you are this kind of employee. So there are different, what they call exemptions under the Fair Labor Standards Act. That means like types of jobs, if you have them and you meet the job duties of them, not just I'm calling you a manager, but really you're in the back like making burgers, like your actual job duties fit these exemptions, then you are not entitled to overtime and you are not entitled to the minimum wage. But for the most part, I see if you are an employer, lean toward not exempt. Lean toward providing minimum wage and overtime until you have someone tell you very specifically that they are an exempt employee and all the reasons why. These lawsuits tend to be very expensive, because to prove them, you have lawyers on both sides sitting down, poring over years of payroll records, time records, if there are none, little hand Post-it notes of everybody, over the years talking about like how long they've worked, calculating that, figuring it all out, and then, in addition, under the Fair Labor Standards Act, if someone is found to have not been paid the minimum wage or the overtime, the employer not only has to pay that money that they're owed to the employee, but it's usually double. They have something called liquidated damages in the Fair Labor Standards Act. And the reason for that is Congress is like, we're not going to be able to wrap our head around like how much 2 years ago $7.25 an hour is worth now. Like, we don't know that. And also, we can't just have the employer giving them what they should have given them in the first place, because then everyone's just going to not pay the minimum wage and hope they don't get caught. And then if they get caught, they'll just have to pay what they should have paid. So there is this kind of, they don't say it's punitive, but it's kind of punitive between me and you, where it is doubled. Unless you can prove that you did reasonably and in good faith rely on information that made you believe that this person was exempt. And that doesn't fly very often. Usually you need like a lawyer telling you, this is an exempt person, that lawyer being wrong, and then maybe you could not have to pay liquidated damages. In addition to the liquidated damages, you also have to pay the other side's attorney's fees and costs, which, as I said, it takes hours to even calculate this information of attorney time. So it is very worth it to, not make those kind of decisions on the front end that might benefit you, because you don't really want to have to pay them overtime. That's kind of expensive, but let me tell you, if you get caught, it's way expensive. It's way expensive. So
what is the reasonable and customary fee fees of lawyers to litigate some of these issues, so you wouldn't want to go into it.
Well, I can tell you it depends on the state. So, where these cases got their momentum is in California and New York. Those are like the cases where they kind of started. Your legal fees out there are astronomical. Here, typically, like a mid-level associate, it's probably $250 an hour. A partner is $400 an hour. Or in my case, I don't have a partner, but just like the guy who owns the firm is going to be $400 to $500 an hour.
Whether I'm a plaintiff or I'm a defendant.
Well, no, you do not get your fees if you are the defendant and you win, unless you can somehow show that it was frivolous. So if you are the defendant, you are paying your lawyer's fees, you're possibly paying the damages, you're possibly paying liquidated damages, and then you're possibly paying the plaintiff's fees. So it is not worth it to be flippant with this stuff. I've slid to this. This is the exemptions. So another reason that this is kind of a complicated area of law is because there are typical exemptions, and then there are more kind of like random exemptions that we can kind of talk about later. If you are an hourly employee, if you are performing manual labor or hourly work, that person, I can't really think of a world in which they would be exempt unless they're a truck driver or maybe teachers aren't paid by the hour. So maybe a truck driver. That would probably be the only situation when you're an hourly worker and you're performing some kind of manual labor where you're exempt. The exemptions are created for true executive employees, administrative employees, and professional employees. Like I said, there are a few other exceptions that I'm not going to get into the weeds on because I'll be here all day. Executive means you are managing other employees. So what I see all the time is someone coming to me and they're telling me that they're not getting overtime, they're not getting minimum wage because they got a promotion and their employer said they're a manager, but they have no decision-making capabilities of their own. They can't hire, they can't fire, they can't do anything without getting an okay from someone else. If that is the case, you are not a manager. It doesn't matter, the super duper management title they give you does not matter. It is your job duties that determine what your exemption is, if any. And like I said, if you're curious about this, each exemption has a very specific job duties test that is on the Department of Labor website that is very easy to understand. Not easy to understand, but it's not written in your typical legalese that a normal person, I think, wrote it, not a lawyer. So the administrative exemption is another tricky one. You are actually administering the affairs of the entire department. My office administrator is an administrator because she is in charge of everything. Nothing moves without this lady's fingers on it. She knows all of it. She has got great decision-making capabilities. Her decisions are bound to the company. They are the company's decision. So that is an administrative exemption. Professional is like an advanced degree. So one way I kind of talk about the professional exemption is nurses. So typical, if you are like I'm not going to talk about that because I can't remember the names of the different ones now, but sorry. Basically, you need an advanced degree, and it's not just that you happen to just have this doctorate that you got like a couple years back in, Buddhist studies, and you are, working at a company doing, I don't know, like writing or something. It has to be an advanced degree that you're using for the job that you're exempt for, or higher learning, like a lawyer. So those are the typical exemptions. And then I think I already said this, but overtime pay has to be not less than 1.5 times the regular rate of pay, and that is for every hour over 40 in a work week. So that means if you work if you are paid biweekly, and you work 38 hours in the first week, and you work 42 hours in the second week, and that adds up to 80, you are still owed overtime for that 2 extra hours in the second week you worked. It doesn't average out. It's in a 7-day work period. Another typical thing that I think people think about, these are the fact sheets that I love so much. There's an example of one. Another thing that I hear all the time, actually from my own mother, she told me this, and I'm like, Mom, I've been doing this forever. How did you not, she's like, well, I can't get overtime because I'm salary. I'm like, that's not a thing, Mom. Like, the fact that you're paid salary does not mean you don't get overtime. It has to be your job duties. So it might be that they are improperly paying you, and just because you're getting paid a salary does not mean you're not entitled to overtime or minimum wage. So I've talked a lot about the specific ways that you could not be paid minimum wage and overtime issues in the handout that I gave you. Let me grab it so we can go through it together. So the reason that past, so this is the Missouri minimum wage that has been from 2013 through 2017. So that means that Missouri's minimum wage is higher than the federal minimum wage. You are entitled to that higher amount. So if you've got an employer who is out of state, who has a minimum wage that's just the federal minimum wage, and your job is in Missouri and everything's in Missouri, you get paid at the higher rate, or you have a case. The federal law is the floor, not the ceiling. So some of the ways that people end up not getting, it's usually not that an employer's like, hey, I'm thinking about paying you like $6 an hour. Are you okay with that? Thought so. All right, we're going to do that. That's not usually what happens. You usually start out, quote, being paid the minimum wage. But then what ends up happening is that you do all of this work that isn't counted as work by your employer. And so if you take all of that time in a week that you've been working on behalf of the employer, doing tasks for the employer, and divide it by the time for which you were actually paid, which is sometimes less than that, and it's below the minimum wage, that's a minimum wage case. And sometimes this happens in situations where you have a job where you report to duty at the office, and then you're sent out on all these jobs from that central location, and they don't count your travel time. Well, that is time that needs to be compensated. So if you include all your travel time in your work week, and you divide it by what you're getting paid, and you're under the minimum wage, then we have a problem. And another way that comes in with this off-the-clock time is that they're like, see, you only worked 40 hours this week. Well, not if you count all the time I was schlepping all over the state, doing work for you. That I would be 45 hours. So not only do I need to be paid to get me to the minimum wage, but I also need to be paid time and a half for those 5 hours that you never counted. So those are some ways. And for employers, I want to also say that I don't envy you with this stuff, because it's so hard sometimes, especially now where everybody in the world wants to work from home, and you don't know what they're doing or how long they're doing it, and if you've got someone that you really only want to work 40 hours and they're at home up all night checking, writing emails, and you have no control over that, it's frustrating. So it's very important to get the scope of the work and explain to them, this is the schedule I expect you to keep, and to monitor that they're in fact keeping that schedule. Because if you say, hey, you can only work 40 hours, like I'm serious, only 40 hours, and then they work 45 hours over and over and over again, and you're getting benefit from that, and you never say anything, then you don't get to come back when they sue you and say, well, I told them, a year ago that they could only work 40 hours. You need to actually monitor what your employers are doing. And I know it's hard. It's very difficult, especially, again, in the day and age where you've got, employees who might be working from home or working remotely, or they work at the office and then go home and are emailing and making calls and doing all kinds of things. So it's important to get someone on your team who understands this and who can give you some, tips on how to manage that type of stuff. Oh, yeah.
This is day and age of the digital age where you've got people that can work from home. We're an employer that says the only way we consider that you have worked at home is if you do the called VPN session from your company owned computer to the server on our premises, and it would let you only see the company email there. It would only let you make telephone calls through there, and that was how they tracked if somebody had worked at home.
Right. And so that's a great way to do it. But the issue comes into play where you've set up this great system and you've asked all your employees to only use the system, but then you become aware that there might be some other task that they're doing on your behalf that doesn't involve that, or for whatever reason, this person's using a different email. You become aware that they're doing it. You don't stop them from doing it. They're still doing the work on your behalf, and you've benefited, and you're still stuck. But it would be, that is a great thing. It tends, if you're an employee an employer who can, have those kind of systems in place.
I have a question.
Yes.
You talked about charging for the time that you're driving. Is there any rule of law that says anything about paying for mileage?
Well, that
in the car as well?
It depends. It depends. And I want to be clear, you are not always entitled to time for driving. So you going to work or you going home is not something that's compensable. So there's a guy in town named Mark Potashnik, and he does wage and hour cases, and his specialty are those types of kind of mileage cases. And I'm not going to get into it because it's kind of a specialty, and I don't want to direct anyone in the wrong direction. But basically, certain types of jobs in which you are using your vehicle for the benefit of the employer, if you, in the pizza cases, what was happening is they were getting reimbursed at a rate that was less than what it costs for the average wear and tear and use and all of that of the car. And then when you take it that a pizza person is making like $3 an hour, you deduct what they weren't making. It took them well below the minimum wage, and now they have all those class actions on those. So that is a good question. It is a thing to be aware of, but it is a very specialized. Wage and hour itself is very specialized, but that is a very specialized area within wage and hour itself. But it's a very good question. And talking about improper, and then another thing to realize is a kind of a place where the law is not great in Missouri or the federal law is these situations where you have employers that are deducting things from your paycheck that are kind of making you mad and frustrated, but it doesn't take you below the minimum wage. In Missouri, if it doesn't take you below the minimum wage, there's nothing I can do from a wage and hour perspective. There might be some lawyer who can do it from a contract perspective or something else, but if they are taking deductions out of your paycheck each week, and then that and the amount you're left with is less than the minimum wage, then you have a case. But if it's $2 a week, it's frustrating, but there's not anything from like a legal perspective in this area that I would do or you could do. Do I have a couple questions? Yes.
What kind of deductions are you speaking?
Yeah, sometimes it's like employee uniform cleaning, like that they just deduct, on a monthly basis. Or sometimes they sign you up for benefits you never asked for or you don't want. What did you say, Joan? Yeah, the uniform is the most common, but you just be surprised, or they're just not getting your pay right. That you're supposed to get paid $7.50 an hour or $10 an hour, and you're getting paid $9 an hour. Like, that's an improper deduction, but unless it's taking you under the minimum wage. And again, there could be other courses of action that exist under contract or general common law, but I'm not aware of them. And this is, it would not be actionable under these particular statutes. So I am pretty much done. I mean, there's so much I could talk about, but I don't want to bore you. I don't know if you noticed, I'm really excited about it. But if there's any more questions on this topic, I'll take them. Otherwise, I'll hand it over to Sheena. Yes.
Say how you felt about that, what we were talking about before, and I asked you, I asked how she felt about one more time, right? I didn't know if you somebody else was interested, but how she felt about that contributing.
The contributing factor. Yeah, we can talk about general questions at the end. I mean, I don't really know that it's appropriate for me to use this as a platform to to explain to you the politics of it, but I work under the current statute, and I think the current statute's doing just fine, if that says anything. So, does there any more questions on for me? Okay.
Okay, and I'm going to talk about another government agency, and this is a federal government agency, the National Labor Relations Board. Most people will think the National Labor Relations Board has to do with unions, right? Not so. That's what I'm going to talk to you about. So the National Labor Relations Board enact, or they administer the National Labor Relations Act, and most of it does have to do with unions. The vast majority of it has to do with unions. And then there is an Employee Bill of Rights that is contained in the National Labor Relations Act. And the point of the Employee Bill of Rights is so that you as an employee have the opportunity to engage in what it calls concerted activity, which could lead to unionizing, right? So the National Labor Relations Board has said, I don't just regulate when there is a union, I also regulate when there is an opportunity for people to talk about terms and conditions of employment, because that's how you form a union, right? So it's actually Section 7 of the National Labor Relations Act is the Employee Bill of Rights, and it gives you, as employees, the opportunity to talk and engage with one another, and it's called concerted activity, to talk about the terms or conditions of your employment. One of those could be wages, right? How much you're paid. One of those could be how much vacation time you get, something like that. You have the right to talk about those kinds of things, working conditions, with other employees. Section 8 of the National Labor Relations Act is really the enforcement piece, and where it's made illegal for employers to stop employees from talking about those things. And the way that I think should talk about these things today is to talk a little bit about social media. I'm going to skip this next slide. So this is a really important, I think, part of what's going on today, because we have so many different social networking sites. And people can put things out all of the time on these social networking sites. And a lot of times it's about people's jobs, their bosses, their employers, their coworkers, things of that nature. And so it makes it so that employees have to be really, really careful, I think, what they say online, and that employers have to be careful how they draft their policies, right? Because you have freedom of speech. And you have this Section 7 and Section 8 of the National Labor Relations Act that says that you have the right to talk about the terms and conditions of your employment, right? So from the employer's perspective, what the National Labor Relations Board has said is that you can't just have a general policy that says do not speak negatively about your employer on social media, right? Because that's just not workable. They can have policies that say use your best professional judgment when engaging in social media. Other approved language, you cannot speak on social media or maybe to the media in the name of the employer, right? So you can't go and say, I work for St. Louis County or whatever it is, and this is St. Louis County's position on X, right? You can be prohibited from doing that by the employer, because they could say only the CEO or only the county executive can speak on behalf of the entity, right? That's allowed. There's also certain things the employers can say what you can and can't do on social media, for example, in a uniform that bears the name of the employer. That's allowed. They can also say that you can't say anything on social media that would violate a law, right? So they could say, use your best professional judgment and don't violate our anti-discrimination policy or anti-harassment policy or something like that. They could also say, don't violate HIPAA, right? So if you're a human resources person and you get information about disabilities, they could say you can't share that information out, publicly. Or if you are working for maybe a publicly traded company, you could be prohibited from maybe tweeting about the fact that your company might sell, right? Because that's a violation of Sarbanes-Oxley, and it would be insider trading if someone was to read and get a hold of that information and you were to share it with them that way, right? So there are ways that employers can specifically say not to violate a law that the employer has the obligation to enforce, right? So the employer has the obligation to keep, if they're a publicly traded company, things like that under wraps and not allow people to use them to trade stocks. Or they have an obligation to protect people from harassment and retaliation and things like that. Another thing is that the employer can't say that you can't say anything negative. What the standard is, if you got onto social media and you said my boss is a jerk or something like that would, because that has happened in cases, or some variation of that, that's one thing. But they can say, what you can't say is something that is maliciously false or unreasonably egregious, or something that is damaging to the product or service that the company is selling. So a company can say, you can say that our product is defective, it's not defective, right? Because that affects the business. And from an employee's perspective, when you're getting out on social media, if you want to stand on those National Labor Relations Act rights to engage with your coworkers about, use that concerted activity to talk about working conditions, terms and conditions of employment, there has to be another employee, right? In order for you to stand on that. Not to say that you don't have freedom of speech otherwise, but if you want to use this law to protect the speech that you're engaging in for purposes of pay and talking about terms and conditions of employment, you can't be talking to your grandma. You have to be talking to your coworker, right? And that's not only in the social media context, but it's coming up a lot in litigation in the social media context, but that's at work too. You can talk with people about, I think employers make the mistake a lot of times of saying that what you're paid is confidential or something like that. It's not confidential. They may hold it confidential because it's your personal information and they may not spread it that way. They may take it seriously and say, we're not going to share what everyone makes. Or they may be the opposite and be totally transparent and say what everybody makes. But you, with that being your personal information, you can share it with coworkers and talk about working conditions that way. Any questions about that? Yes?
So you're saying that if you're talking on the phone to your grandma, but if you're on social media, you can't say, oh, they keep the air conditioning too high, and I think that they don't pay enough for the work we're doing, and having that, because you're not having a conversation with another.
What I'm saying is you could say whatever you want to your grandma, but if you want to be protected by this law, it protects those conversations among employees and not you and grandma's conversation. You see what I'm saying? Mm-hmm.
If you communicate on social media from a work computer, is that different from communicating at home under the law?
It depends on the employer's policy, not on the law. So most employers have a policy that says that you can only use the company's equipment for business purposes and so on and so forth. And so no matter what you would have said, if you would have been saying, this company is awesome, the fact that you're on Facebook and you're supposed to be working, that could get you disciplined. But from a legal perspective, it's usually the company's policy. And most companies will have a policy about using their email, using their computers, all of that stuff, and just generally not, quote unquote, stealing time at work is what employers might call it, by not doing the actual job that is assigned to you when you're working. Sir?
I have worked places where part of employment, the first day where they tell you the policies, and they specifically said you are not to discuss pay, working conditions with other employees, any issues bring to human resources. So what you're telling me is that which they put to you, you've got to sign, is not really enforceable or legal.
That's correct. You do have the right to talk about working conditions and pay and terms and conditions of employment with other employees. It's called concerted activity, and it's protected by the National Labor Relations Act. Now employers can ask you and have a policy that if you have a complaint, take it to the Human Resources Department. They can encourage you to do that, certainly. So that second half, that's perfectly appropriate. But you also can't say that people can't speak about it. And you don't want to get into the situation where if you're a small business or something like that, or you're a manager, where you think the National Labor Relations Act doesn't apply to you because you don't have a union workforce. Because that part of it, that protected concerted activity part, which is usually how unions form, applies to you whether or not you have a union, because it's how the unions form. Sir?
On a separation agreement, how much can they hold the employee who is leaving to that agreement? Can they tell you that you can't say anything about the company?
That's a lot longer story. Whether you can, it depends, right? It depends on who you are and things like that. So if you take a step I'm just going to give you 2 examples, and then maybe you and I can talk after, because this seems like a little bit of a, he's asking how much you can be held to, I guess, confidentiality and keeping the employer's business confidential when you're leaving the company. If you sign a severance agreement, for example, you take a severance package, typically that's associated with a confidentiality clause, and the company is not forcing you or tricking you into keeping it confidential. Instead, they're paying you to do that, and you've accepted a benefit in that regard, right? So that's a little bit different. But then there are also competitive jobs, like you are a salesperson, you have access to a client list, right? And you had a non-compete to begin with that said that when you leave, you will not use this client list or let this proprietary information out for a certain period of time, right? So there are all kinds of little different ways that things can be kept in and may not be. Any more questions about this?
I had a question. I know that there's legislation possibly about right to work in Missouri, and I'm just curious if that has any effect on the National Labor Relations Act, or like the way that employees can interact with each other in terms of forming unions or having these concerted actions.
No, right to work doesn't have anything to do with this. It does still, you are still allowed to have those conversations. Right to work is about whether or not you have to pay union dues if you don't want to, basically.
I'm a petitioner, and
just 1 second.
Employees are talking about what they're being paid, and it's a small employee, like a 10-person office. You can fire them for that, can't you?
Say that again?
Can you fire somebody for talking about their pay at work and in a small employer of 10 people?
I'm certain that I could think of ways in which you might be able to do that, right? But it's not on the basis that they were talking about their wages. So, for example, if I have 5 employees and the 5 employees have all told each other how much they make and I don't like that, that's not a terminable offense, right? They have the right to talk about that. If you're saying, though, that they're supposed to be working, right, and they're talking about that instead, then you can ask them to do their work. And typically what any employment lawyer who represents management side folks would say is that you want to use progressive discipline to the extent that you can.
Well, I'm just thinking in a small office, how disruptive if somebody's making 15 and somebody else is making 10, and the mess that can occur with that. And one of the first statements that you made coming into this is you can get fired for really any reason. I thought you said that.
And then I told you that we were going to tell you about all of the exceptions to that, right? Yeah. Well, all of these things that we've been talking about are exceptions to that. But yes, employees do have the right to talk to each other about how much money they make. And I think we're going to talk about the next topic, and we can talk offline if that's okay. Okay. Want to go first on this?
So this is the duty of loyalty. So where this comes up is actually, it comes up in a variety of ways, but in the ways that we mainly see it, or I mainly see it, is actually in a separation context. And that, if you are leaving your employment in a not so nobody's really happy with each other. It's kind of a bumpy situation. What you don't want to do is make sure you wipe your hard drive and take all of your secret company information with you. So what we're starting to see a little bit more of in our whistleblower cases, or even in certain discrimination cases, is countersuits to our plaintiff for doing just that, for stealing company information and taking it with them. There's a specific federal act that if you do it, over the interwebs or the computer, you can have a claim for that. So, even when tempers are rising high, you don't feel like you've been treated fairly, you don't think that this is ending in a way that you believe is fair, possibly illegal, the things that you don't want to do are just that, or take all of this information with you. Or if you think you're building your future case, taking this information. And this typically, it is particularly an issue in situations where you have a sales position or tech now is, everybody works for tech in some way. I feel like who calls me anymore. And, you have these people who have been developing a specific product that's very hush-hush, because if anyone finds out about it, the whole company has been devoted to this one product forever, and if any of it gets out, they could lose decades of work. So that's the type, taking or patent information or things like that, what they call confidential information. Now, sometimes it can be that an employer is mad at you because you're leaving and they've claimed you've taken confidential information, like a quote customer list that is actually like publicly available to anyone who really wants it. It can't just be confidential because the employer says it's confidential. It actually has to be confidential information. And if you want to talk a little bit about that.
No, that's correct. I think the client list example is the most common. When you have a salesperson and they are working for one bank, they move to another bank and they want to take their clients with them. So that is the most common of those. But there are even things that are less onerous or less expensive for the company than that. Policies, procedures, things like that, companies consider proprietary information. So if the company has let's say you're a manager somewhere and the company has come up with some sort of matrix for how they evaluate employees and things like that. That's the kind of stuff you really don't want to take with you. And what we'll often see is that employees will bring like a thumb drive to work on their last day and they want to download all their contacts or whatever and take everything else along with it. If the contacts are considered proprietary by the employer, that can be actionable. If some of the policies and procedures, to the extent that they're unique, which some employers do consider, if, for example, their performance evaluations or how they evaluate people for promotions and hiring and things like that, they consider that proprietary. And so it could be a problem if you take that and go to a different company. And one of the main ways that I see this is when we have business partners splitting up, and not really even partners, but people who've been in the business a long time together and grown a business together, and one of them leaves and wants to start another business that's competing. So typically you'll be in a competitive situation or in a litigation situation or something like that, but under no circumstances do you want to get yourself wrapped up in taking things that are proprietary, confidential information, trade secrets, all of the buzzwords like that you would use in trademark sense or any of that. Copyrighted material, all kinds of things like that can get you into a situation where you might have a counterclaim.
Right. And also, people in medical, HIPAA still exists when you leave. So if you are a nurse who you think was wrongfully terminated and you have taken all of this patient information with you because you think it's going to help your case, even you're not so good because it's HIPAA. I mean, it's still HIPAA. So you want to make sure that you're not or if you're in HR, and you have all of this HIPAA information or something like that, it still applies to you when you leave, and it can be actionable if you try to take that information with you when you go. Your lawyer, if you are, worrying about a case going forward, if there's some things that are out there that exist, then, there are legal ways to go about getting that information. So we've got about 5 minutes left. We can start taking questions. Sir, here in the red jacket.
Isn't it get a little bit gray for someone, say, who's worked for a company for a long time, has got a lot of experience, not necessarily taking a thumb drive or a physical list or something, but just knows?
You got it in your hand, yeah.
Yeah, you take it with you in your head, and that experience, and you apply it to your next job. And doesn't it get a little bit gray with the question of that duty of loyalty? I mean, in terms of how you use what you learned in the last job, in terms of how what your prior employer did, what their processes were, you're bound to take that experience with you and those processes with you, whether you take them in a written form or a thumb drive.
That's true. Usually, because obviously, if you're a salesperson, you know who your customers are, right? So it's kind of in your head. But typically, what the employer will have is a policy that spells out what you can and cannot do when you leave, right? And some employees will argue that that doesn't apply. But to the extent that you are compensated in any way based on that. That's, honestly, it does.
It's a way you evaluate an employee, so when you go to the next job, and you continue to evaluate your subordinates the same way you did at your prior employer.
I think that's a little bit, so if you personally just go and evaluate the people who report to you the same way that you did at your last job, and you build on your experience from one employer to the next employer, that's one thing. If you go to the next employer and you say, I would like to change the way that we evaluate employees company-wide, here's my idea, that's a little bit different, right? And typically these things, don't come out just because you use your experience at a different employer. Typically they come out when you're competing with a prior employer or when you're in a litigation situation, right? So it's not just every single case. Normally people don't follow their employee that's leaving the company to the next job to see exactly what they're doing or what they took with them. But if you're in a contingent situation, occasionally they will.
Yes, sir.
Could you talk about, I believe they call this the duty of honest labor. This was something that in the early part, 2000 or so, where you would read about, called corporate espionage, where somebody would go to work at a firm supposedly as an employee, and they would work as an engineer, but they were really on the payroll of an industrial espionage company, trade secrets. And what happened is when this was found out, the company would sue this false employee for damages to refund them all the money that they had paid them as an employee because they had not truly been a loyal employee, and they basically falsifying the circumstances of being there. Have I got the right term for that?
I mean, I've never dealt with a case like that, but I imagine that it would come up. So what we were kind of talking about is this other area of litigation that usually happens after the employment relationship is broken up, and it's a competition litigation. So whether the employers, put restrictions on competition after their employee leaves, what is reasonable, what is not. I mean, people litigate that every day. And to your question, I don't know a specific act that deals with the duty of honesty, but especially in trade, there's probably, Sarbanes-Oxley probably deals with stuff like that. It's just not something I'm specialized in.
Criminal case.
Yeah, it could also be a criminal issue. So maybe we have time for one more question. I'm sorry, I can't. Oh.
How exactly do you calculate damages caused by breach of confidentiality?
Well, there are multiple ways to do so. Some of it is, How do you compensate damages for someone who's breached How do you calculate damages for someone who's breached confidentiality? It kind of depends on
what your job was. And it's like really easy if you were a salesperson, you took 3 clients and those clients had $1 million book of business each, right? But it might be a little bit more difficult if you took something that is proprietary, a trade secret or something that the employer considered. In that case, they're usually, in addition to seeking money damages, they're going to be asking for what we call a declaratory judgment, and that is like an order of the court telling that you can no longer do what you're doing, right? So I think it's a little bit harder when we're talking about a process versus something that we can put money value on. And employers will a lot of times try to put a money value on whatever it is that is the trade secret as well. If they're developing a product or something like that and you take the idea, they will try to calculate what they think they would have made and have to prove that in court.
And that comes down to whether the jury buys their calculation or not, you know. But usually what the employer is seeking, if it hasn't, usually what happens is they stop. They file a lawsuit to enforce a non-compete or do a temporary an injunction of some sort to stop this person from doing anything, because if they do that, then there's going to be all of this damage that is impossible to calculate. So usually what you're seeing is an action to stop something. And damages do come into play sometimes, but most of the time it's just an action in court. And not every statute allows you to do that. But in this case, they could go to court and say, Judge, they're breaking the law, they're not doing this agreement. If they keep doing it, there's no way I'll ever be able to be paid back for this. And the judge will or will not enforce an injunction. So, oh, okay. Thank you. So my email is on your Know Your Rights sheet. So if anyone has specific questions for me, feel free to send me.